Oh, hello. Welcome to my bar review show. Today we're talking about real property. Real property involves ownership, landlord and tenant, land sale contract, titles, mortgage and security interest, and land use disputes. I group land sale contracts, titles, mortgage and security interest into one group that I call sales. We've got ownership, landlord-tenant, sales, and land use disputes. Ownership, landlord-tenant, sales, and land use disputes. Ownership involves present estates, future interest, concurrent estates, co-tenancies, and special real property issues. Present estates. Estate is freehold if immobile and for indeterminate duration. We've got fee simple, a defeasible fee, and a life estate. Fee simple. Absolute ownership of potentially infinite duration. To A or to A and his heirs, freely alienable and no accompanying future interest. Defeasible fee. A string is attached. Potentially infinite duration, subject to termination by event or occurrence. Alienable, divisible, and descendable. Fee simple determinable. General durational string attached. Limited by specific durational language, so long as, while, during, until. Automatically terminates on stated events happening. Future interest is a grantor or his successor in interest retain a reverter possibility. Fee simple subject to condition subsequent. Specific conditional string is attached. Present fee simple is limited by specific conditional language, on condition that, provided that, but if, or if it happens that. Will terminate only if grantor affirmatively demonstrates intent to terminate. Future interest. Grantor must specifically retain a reentry right. Fee simple subject to executory interest. Present fee simple limited by specific durational or conditional language. Automatically terminates on stated events happening and title passes to third party. The future interest, executory interest held by third party, someone other than the grantor. Extra. Restraints on alienation of fee simple are generally void. Direct restraints on grantee's right to dispose of property by will or intestacy are also generally void as restraint on alienation. Life estate can be subjected to restraints on alienation. Certain types of indirect restraints have been held up by courts as well. For example, use restrictions are an exception to the general rule against restraints on alienation. Life estate. Present possessory estate, fully transferable during measuring life. If third party, to A for life. To B after A's life, or to B for C's life, por ultra V. To A for life, but if A drinks, then to B. That's a defeasible life estate. If measured by grantee's life, not divisible or descendable by grantee. If measured by another's life, life estate may be divisible or descendable. Life estate may be cut short by specified event, a defeasible life estate. Life tenant's rights. Right to possess, right to collect rents, right to lease, sell, or mortgage. Must pay taxes on financial benefit from land. All right, let's talk waste. It limits life estate holders' rights. Life tenant must deliver property to future interest holder in substantially same condition as when life tenant took possession. Permissive. Occurs when life tenant lets the premises deteriorate via neglect, failure to preserve, or failure to reasonably protect property. Life tenant must make reasonable repairs up to income amount property produced. Or, if life tenant is in actual possession, fair rental value. Voluntary. Occurs when property's condition is substantially changed due to life tenant's affirmative action. Property's value decrease, not permitted. No decrease in property value is ameliorative waste. It's permitted when a change results in property's reasonable use, unless future interest holders have a reasonable objection. Holder of any future interest may bring suit against life tenant for injunction. Allocation of burdens. Life tenant must pay property taxes to extent life tenant receives financial benefit from land. Pre-existing mortgage obligations and assessments for public improvements are allocated between life tenant and future interest holder. All right, we're moving on to future interest. Ownership interest in presently existing property, which may commence in possession or enjoyment sometime in the future. We've got reversion, reverter possibility, re-entry right, remainder, executory interest, transferability, class gifts, survival contingency, and finally RAP, rule against perpetuities. Reversion. Held by grantor who transfers life estate or estate for years without conveying the remaining future interest to a third party. It's not subject to RAP. It's alienable, divisible, and descendable. Reverter possibility. Future interest retained by grantor when fee simple determinable is conveyed. Alienable, divisible, and descendable. Re-entry right, terminate right, entry right, or termination power. Grantor retained future interest after fee simple subject to conditions subsequent is granted. It's alienable, divisible, and descendable in most states. Remainder. Future interest that becomes possessory on natural expiration of prior estate, created in the same conveyance in which remainder is created. We'll talk about vested and contingent. Vested. Not subject to any conditions precedent. Ascertainable grantee. Vested remainder subject to open. If at least one class member is qualified to take possession at conveyance time, but less than all of them, each class member's share is subject to partial diminution because additional takers not yet ascertained can still vest. Vested subject to complete divestment. Occurrence of conditions subsequent will divest remainder. Contingent. Created an unascertainable grantee or is subject to express condition precedent to grantee's taking because of unknown beneficiary or known beneficiary subject to condition precedent that has not yet occurred. Executory interest. Future interest in third party, not remainder, that cuts prior estate short on specified conditions occurrence. Transferable and RAP subject. We've got shifting and springing. Shifting. Cuts short prior estate created in the same conveyance, so estate shifts from one grantee to another grantee on conditions happening. Springing. Divests grantor's interest or fills in possession gap in which estate reverts to grantor. Transferability. Remainders or executory interest are transferable inter vivos, meaning during life, and they're divisible or descendable. Class gifts. Transfer to group member. Beneficiaries and gift amount are subject to change. Survival contingency. When ambiguous, Majority applies at termination of interest that precedes the remainder. The minority requires surviving only the grantor, not the life tenant. All right, rule against perpetuities. Specific future interests are valid only if they must vest or fail by the end of a life in being plus 21 years. Affected future interest. RAP applies to contingent remainders, vested remainders subject to open, executory interest, and appointment powers. First refusal rights and options may be RAP subject unless commercial. RAP does not apply to future interests that revert to grantor, reversion, reverter possibility, and reentry right. Measuring lives. They must be human. There can be no more than one. If not specified, the measuring life is life directly related to future interests subject to RAP. Creation events. RAP tests the future interest as of time future interest is created. Vest or fail requirement. If any possibility exists, it will not be known whether interest will vest or fail within the applicable period, then RAP has not been satisfied. Violations effect. Except in rare cases when voiding future interest undermines grantor's intent, only offending interest fails. Special rule for class gifts. Bad to one, bad to all. If RAP voids transfer to any class member, then transfer is void as to all class members, even those whose interests have already vested. Convenience rule. Can be operated to prevent RAP's application to class transfer, but convenience rule's application to class transfer does not automatically forestall RAP's application. Exceptions. Transfer of specific dollar amount to each class member. Transfers to subclass that vest at specific time. Charity to charity exception. If property passes from one charity to another, RAP does not apply. Common violations. Survival beyond age 21 condition. Fertile octogenarian. Unborn spouse. Defeasible fee followed by executory interest. And finally, conditional passage of interest. All right, we're on concurrent estates. This involves tenancy in common, joint tenancy, and tenancy by the entirety. We also have rights and obligations. Tenancy in common, default co-tenancy, two or more grantees with unity of possession. No survivorship right. Each co-tenant holds undivided interest with unrestricted rights to possess the whole. Interest is freely divisible or transferable. Joint tenancy. Two or more persons own property with right of survivorship. Four unities: possession, interest, time, and title. Equal rights to possess the whole, with identical equal interest, created at the same time and by the same title. Severance converts joint tenancy into tenancy in common, but only with respect to severed share. Sale. Don't need consent. Sever joint tenants as to seller. It severs the joint tenancy as to seller, but joint tenancy of the non-transferors remains intact. Mortgage. Severs joint tenancy via title theory, but not via lien theory. Judicial lien. Lien typically will not sever a joint tenancy. Severance occurs when the property is levied and sold. Tenancy by the entirety. Same unities of joint tenancy. Possession, interest, time, and title, plus unity of person, so it's possession, interest, time, title, and person. Parties must be married to each other when deed is executed or conveyance occurs. Neither party can alienate or encumber property without the other's consent. Recognized in about half states. Where recognized, majority presume conveyance to married couple creates tenancy by the entirety, and divorce converts a tenancy by the entirety to a tenancy in common. Rights or obligations. Each co-tenant has a right to possess the entire property, and generally not required to pay rent when other co-tenants do not use the property, unless co-tenant has been ousted. Co-tenant can collect contribution from other co-tenants for operating expenses, like taxes, but if in sole possession, only if operational expenses exceed property's rental value. Co-tenant cannot compel other co-tenants to share repair expenses by contribution action, but may maintain separate action for contribution in some states if notified the other co-tenants of the repair need. In accounting or partition action, necessary repair expenses recouped indirectly. Co-tenant has no right to reimbursement for improvements, may be entitled to additional value in partition action. Co-tenant must account for rent received from third parties, but can deduct expenses. Net proceeds are divided among co-tenants based on ownership interest. Co-tenant owes other co-tenants fair dealing duty, but generally does not owe other co-tenants fiduciary duties. An exception is when a co-tenant buys property at tax or foreclosure sale. Other co-tenants can buy back their interest within reasonable time. Partition. Tenancy in common or joint tenancy, but not tenancy by the entirety, generally has right to unilaterally partition property. Partition in kind, preferred by courts, is property's physical division. Easements. Co-tenants may agree to create an easement. Unilaterally created easement is only enforceable against the co-tenant who created the unilaterally created easement. Special real property issues. Fair housing and discrimination. Fair Housing Act, FHA, prohibits discrimination in homes renting, selling, and financing, and in other housing-related transactions, advertising, homeowners insurance, and zoning. Exemptions. Owner-occupied buildings with no more than 4 units, including the owner's unit, and single-family homes sold or rented without broker are generally not subject to FHA, but are subject to advertising rules. Protected classes. Prohibition applies to discrimination based on race, color, religion, national origin, sex, disability, and familial status. Racial discrimination. Plaintiff need only show disparate racial impact, not racial intent or purpose. Conflict of laws. Generally apply law of situs in real property cases. Situs is the state where real property is located. Exceptions. When a doc that conveys or transfers land interest specifies an applicable law. When dealing with property acquired during marriage, the law of spouse's domicile when property was acquired determines whether property is marital or separate property. Collateral issue, like a land transfer attacked as fraudulent, it knows the law of the state with the most significant interest may apply. All right, let's take a break. You can pause the video here and come back when you like. All right, let's talk about landlords and tenants. Landlord and tenant involves tenancy types, tenancy duties, landlord's duties, tort liabilities, and assignment or sublease. Tenancy types. Tenancy for years. Any fixed time period. Automatically terminates at term's end. No notice is needed. May be terminated before term's end. Lease covenant breach gives rise to right to terminate. Created by express agreement. If term is longer than 1 year, statute of fraud applies. Written lease signed by party to be charged must ID the parties, premises, lease duration, and rent to be paid. What's wrong with my VCR? All right, periodic tenancy. Repetitive, ongoing estate by set time periods, with no predetermined termination date. Term may be fixed by parties or by their actions. Automatically renews at each period's end unless valid termination notice. Statute of frauds does not apply unless initial term exceeds 1 year. Created by express agreement, implication, or law operation. Must be given before last period. Must be given before last period begins. Late notice is effective for next period. Generally effective as of period's last day. Oral notice is sufficient under common law, but most states now require some writing. Tenancy at will. No specific term. Continues as long as landlord and tenant want. Created by express agreement or by implication. Either party may terminate. At common law, no notice was required, but landlord must give tenant reasonable time to vacate. Most states now require notice. May also be terminated by law operation. Tenancy at sufferance. Holdover tenancy. Tenant wrongfully remains in possession after lease's expiration. Tenant is bound by lease term that existed before expiration, including rent payment. Tenancy lasts until tenant vacates, landlord evicts tenant, or landlord elects to hold tenant to periodic tenancy. All right, tenant's duties. Pay rent. Duty to pay unless premises is destroyed, lease ended and tenant excused, or landlord's material breach. Avoid waste. Affirmative waste. Tenant is prohibited from committing voluntary waste. Ameliorative waste. Tenant may change property's physical condition and increase the property value if reasonably necessary for tenant to use property in reasonable manner, unless landlord and tenant agree otherwise. Permissive waste. Unless relieved by lease, statute, or ordinance, tenant has duty to repair premises to keep it in its pre-rental condition. No duty to repair normal wear and tear, unless landlord and tenant agree. Repair. Non-resident commercial leases. Tenant may be contractually liable for all property damage. Failure to pay rent, the majority. Landlord can sue for damages and evict and terminate lease. Could not evict or terminate lease at common law. Future rent. No anticipatory repudiation in most states. Where anticipatory repudiation applies, damage is limited to difference between future rent under lease and either reasonable rental value or actual rent collected from reletting. Late rent. Landlord is entitled to damages. Whether landlord can sue to remove depends on if breach is material or if landlord waived right to evict by accepting late rent. Abandonment, treated as offer to surrender rights under the lease. Landlord accepts surrender. Lease terminates and liability for future rent ends. Landlord rejects surrender. Tenant remains liable for rent, but under the majority rule, a landlord has a duty to mitigate damages. Holdover tenant. Landlord can accept holdover tenant as periodic tenant or tenant as sufferance, or sue after notice to vacate. Landlord's duties. Possession. Landlord must deliver actual physical possession or no obligation for tenant to pay rent. Repair. Except for tenant's damages, landlord must repair for residential but not commercial leases. Warranty of habitability. Premises must be fit for basic human habitation, health, or safety, and if breached, tenant must notify landlord of defect and give reasonable time to repair, and then tenant can refuse to pay rent, make reasonable repairs, and deduct the cost from future rent, or remain in possession, pay rent, and seek damages. Quiet enjoyment. Breach may amount to eviction. A tenant has a right to the premises' quiet use and enjoyment without the landlord's interference. Landlord has duty to control other tenants' nuisance in common areas. Actual. If landlord excludes tenant from premises, then lease is terminated and tenant's obligation to pay rent ends. Partial. Tenant is excused from paying rent to partial. Tenant is excused from paying rent for landlord's partial eviction, but must pay reasonable rental value if partial eviction by third party with superior claim. Tenant is not excused from paying rent for partial eviction by adverse possessor or trespasser. Constructive. Substantial interference caused by landlord's actions or failure to act. Tenant must give notice of problem. Landlord fails to respond, and tenant must vacate premises within reasonable time after landlord fails to fix the problem. Retaliatory. Landlord may not evict residential tenant for reporting housing code violations or refusing to pay rent when landlord breaches warranty of habitability. Defense is not available for a tenant in arrears. Security deposit. Amount and terms generally are set by state statute. Usually retained in escrow account and must be promptly returned at lease's end absent explanation for retaining it. Tort liabilities. Tenant. Care duty to invitees or licensees or foreseeable trespassers, and may be liable for dangerous conditions or activities. Landlord. Common law. Liable for injuries in common or public areas, non-common areas under landlord's control, or from hidden defect or faulty repair by landlord's agent. The modern trend is there's a general duty of reasonable care, liability for defect existing prior to tenant's occupancy, failure to make required repairs, and third parties who injure tenants' criminal activities. Assignment and sublease. Assignment. Complete transfer of tenant's remaining lease term. Transfer of physical portion for remaining lease term is partial assignment. Sublease. Any transfer for less than lease's entire duration. Parties. Assignee tenant. Assignee tenant is liable to landlord for rent or covenants running with lease because assignee tenant is in privity of estate with landlord. If assignee tenant reassigns lease, his privity of estate with landlord ends, and subsequent tenant is now in privity of estate with landlord. Sublease tenant, not liable for rent or lease covenant. Not liable for rent or lease covenant to landlord because not in privity of estate or privity of contract with landlord, but still liable to the original lessee. If subtenant expressly assumes covenants, then personally liable to landlord. Subtenant can enforce all covenants made by original lessee in sublease, but not any made by landlord. Original tenant is liable for lease covenants unless novation by landlord, because still in privity of contract with landlord. Privity of estate with landlord ends on assignment, but not sublease. Landlord assignments. Generally, a landlord may assign third-party lease right as ownership transfer part, but landlord remains liable to tenant for all covenants in lease. Tenant must pay rent to assignee landlord and obey lease covenants. Assignee landlord must perform any burden imposed by lease covenant. Attornment. Tenant's acknowledgement of new landlord. Usually arises automatically on rent payment to assignee landlord or notice to tenant, but formal acknowledgement of assignee landlord's ownership may be required in commercial leases. Limitations. Tenant can still assign or sublet if lease prohibits it, but landlord can terminate for breach and recover damages. Landlord can only withhold permission to grant assignment or sublease on reasonable grounds in relationship to property being leased, and not on a whim or on a personal prejudice. All right, let's take a break. You can pause the video here and come back when you like. All right, we're moving on to land sale contract. We've got formation, performance, breach remedies, equitable conversion, and finally options and rights of first refusal. Formation, subject to general contract requirements. Real estate broker, agent who owes his principal duties of loyalty, care, competence, diligence, disclosure, and confidentiality. Seller's agent, listing broker, helps sell asking price and advertises property. Selling broker, listing broker sub-agent, they find the buyer. Listing broker and selling broker generally share the commission. Buyer's agent may also receive commission. Dual agent represents both buyer and seller, prohibited in many jurisdictions. Transactional broker does not represent either buyer or seller, but instead facilitates sale by performing various functions, owes each party duty to perform with skill, care, and diligence, and to deal fairly with each party, but does not owe either party loyalty duty. Statute of frauds. Formalities. Land sales contract must be in writing, signed by party to be charged, and contain all the essential terms: parties, property description, price or payment terms. Statute of frauds also applies to other property interests, such as assignments and options regarding real property purchase, and leases over 1 year. A deed need not satisfy the statute of frauds. However, it must be in writing, signed by the grantor, contain property's description, and identify the grantee. The deed must contain words of transfer. Part performance, statute of fraud exception. Buyer takes land possession, buyer remits all or part of purchase price, and/or buyer makes substantial improvements. Most jurisdictions require at least 2 of those 3 acts. Detrimental reliance. Specific performance is permitted when party seeking enforcement has reasonably relied on contract and would suffer hardship. Statute of fraud exceptions. Admission, detrimental reliance, and part performance. In part performance, you can consider all or part of payment of purchase price, purchaser's possession, or substantial improvement by purchaser. All right, performance. We've got marketable title, time of the essence, implied warranty of fitness, duty to disclose defects for all homes, tender of performance, and merger. Marketable title. Title free from defects or unreasonable litigation risk. Seller is generally not required to deliver marketable title until closing. Seller can use sale proceeds to pay off existing mortgage, eliminating related title defect. Buyer can rescind or recover out-of-pocket and earnest money payments, sue for breach, or sue for specific performance with abatement of purchase price. Time of the essence. Is not enforced unless contract part, express or implied, but party failing to perform on closing date is in breach. Implied warranty of fitness. Only for new homes. Warrants adequate materials used and workmanship. Includes latent construction defects. Duty to disclose defects, all homes. Seller must disclose all known material physical defects not readily observable. Tender of performance. Concurrent conditions. So if one party repudiates, the non-repudiator is excused, but buyer must give seller sufficient time to cure a title defect. Merger. Land sales contract obligations merge into the deed on delivery unless obligations collateral to or independent of conveyance. All right, breach remedies. Damages. Difference between contract price and market value in some jurisdictions. Limited to buyer's out-of-pocket expenses if seller is unable to deliver marketable title, but acted in good faith. Buyer's deposit as liquidated damages. Generally, deposits of no more than 10% of purchase price have been found to be reasonable liquidated damages, but courts may consider factors relating to transaction or refuse to enforce liquidated damage clauses when seller suffers no actual loss. When contract is silent, courts consider some factors and usually allow seller to retain deposit when reasonable. Specific performance, mutuality of remedies. Equitable conversion. Contract converts seller's interest into sales proceeds interest, not in real property. Once buyer signs contract, buyer is land's owner on condition buyer pay purchase price at closing. But in the interim between the contract and the closing, the buyer bears the loss risk if land is destroyed. Options and rights of first refusal. These are subject to the statute of frauds. All right, let's take another break. You can pause the video here and come back when you like. All right, titles. We've got adverse possession, deeds, delivery, and recording, conveyance by will, trust, or law operation, and finally restraints on alienation. Adverse possession. Continuous or uninterrupted, actual, hostile, and exclusive. Continuous or uninterrupted, through statutory period, 10, 15, or 20 years. Seasonal use is okay if consistent with property type, like a vacation home. Tacking is permitted, but no gaps and via non-hostile connections only. Descent, devise, contract, deed. Actual. Actual entry giving exclusive possession is open or notorious, but if only actually possessed property portion, constructive adverse possession gives title to the whole. Hostile. Must possess land without owner's permission. Majority of jurisdictions ignore subjective intent. Instead, must show objective intent to claim land as his own. Minority of jurisdictions consider subjective intent. Good faith must believe property is unowned or he owns it. Bad faith is an aggressive trespass. Exclusive. Possession cannot be shared with the true owner, but two or more people can adversely possess as tenants in common. Deeds, delivery, and recording. Deed is a legal instrument that transfers ownership. We've got delivery, deed, recording acts, title insurance, and deed types. Delivery. At transfer time, grantor must intend to make present transfer of property interest to grantee. Typically, intent is shown by deed's delivery. Execution and recording creates rebuttable presumption deed is to be presently operative. Parole evidence is admissible to establish intent when grantor keeps the deed. Transfer to grantor's agent is not delivery, but transfer to the grantee's agent is. Transfer to third party with condition is not delivery if grantor keeps absolute right to recover deed, but if not, treated like a future property interest. If conditioned on death, grantor must intend to make present gift. Acceptance is presumed for beneficial transfers. Deed. Many states allow real estate brokers to prepare real estate sales contract. Some states limit this to form contracts. Some others require attorney review. Non-attorneys may prepare mortgage lending docs. Jurisdictions are split on attorney requirement at closing, but non-attorney may not answer legal questions. Valid deed requirements. Identified parties, grantor's signature, words of transfer, and reasonably definite property description. Extrinsic evidence is admissible. Agent may execute deed. Equal dignities rule. Agency authorization for real estate contracts must be in writing. Recording acts. Types. Notice. Bona fide purchaser for value without notice of prior interest prevails over prior grantee who failed to record. Must record against subsequent purchaser. No real property, conveyance, or mortgage good against subsequent bona fide purchaser for value unless same be recorded according to law. Race. First to record prevails, despite prior conflicting interest knowledge. No real property, conveyance, or mortgage is good against subsequent purchaser of value unless first recorded by law. Race notice. Subsequent bona fide purchaser is protected only if he takes without notice and is first to record. No real property, conveyance, or mortgage good against subsequent bona fide purchaser unless first recorded by law. Notice. Tested as of conveyance time. Notice obtained after conveyance does not prevent purchaser from benefiting from recording. Actual. Grantee with actual personal knowledge of prior interest cannot prevail under notice or race notice statute. Inquiry. If reasonable investigation would disclose prior claims, grantee cannot prevail against them. someone other than grantor has possession, or docs referenced in title chain. Constructive, properly recorded and appears in chain of title. Title insurance, protects policyholder, title insurance protects policyholder, owner, or lender against defects that could have been uncovered by careful title search or forged, undeliverable, unenforceable deeds. Deed types. General warranty, present covenants, good till closing. We've got Sizen, grantor owns land as described in deed. Right to convey, grantor has right to transfer title. Against encumbrances, no undeclared encumbrances against land. Future covenants, these take over after the closing, so you have quiet enjoyment. Grantee is not disturbed in possession by third parties' lawful claim. Warranty, grantor will defend grantee against third party claims. Further assurances, grantor will do whatever future acts reasonably necessary to pass title if later determined title is imperfect. Special warranty, same covenants of title as general warranty deed, but it only warrants against defects arising during time the grantor had the title. A quitclaim deed, no covenants of title. Conveyance by will, trust, or law operation. Will, specific devise or residuary clause. Special situations. Ademption, real property's devise fails because testator no longer owns particular property upon death. Lapse, real property's devise fails if will named beneficiary dies before testator and no alternate beneficiary is named. Anti-lapse statute, prevents gift from lapsing if gift is made to individuals specified by statute, and these individuals leave issue who survive testator. Law operation, intestate succession. Trust, fiduciary relationship wherein one or more trustees are called upon to manage, protect, and invest certain property and any income generated therefrom for the benefit of one or more named beneficiaries. Inter vivos trust, created when settlor conveys his property to trustee while settlor is alive. Testamentary trust, created by settlor in his will. Pour over trust, settlor created during his life, but not funded until his death by devise in his will. Restraints on alienation. Restraints on legal instruments, restraint forms, disabling restraint, prohibition on property interest transfer by its owner, always void. Forfeiture restraint, property is forfeited if interest owner attempts to transfer his interest. Restraint on future interest or life estate can be valid. Promissory restraint, property interest holders promise not to transfer property interest. It's enforceable by injunction or suit seeking damages. Restraint on life estate can be valid. Prohibited restraints. Absolute restraint on alienation of fee simple is void. Any restraint based on race, ethnicity, or religion is not enforceable. Permissible restraints. Property use restraints, covenants, are generally permissible. Restraint on equitable interest. Restriction on transferability of equitable property interests, such as spendthrift clause, is valid. All right, let's take another break, another big break. You can pause the video here and come back when you like. All right, let's talk about mortgage and security interest. They involve mortgage, mortgage alternatives, transfer, pre-foreclosure rights and duties, and foreclosure. Mortgage. Real property interest serves as obligation security. Must satisfy statute of frauds. Lien theory, the majority. Debtor or mortgagor has title and right to possession until foreclosure, and creditor mortgagee has lien and right to land if there is a default. Lien stays on the land if mortgage instrument is properly recorded. Creditor can foreclose by judicial proceedings which terminate junior interest. Subordinate interest must be joined or remain on land, and buyer takes subject to senior interest. Mortgage alternatives. Deed of trust. Trustee holds title for beneficiary. Mortgagee lender cannot purchase property at non-judicial foreclosure sale, but beneficiary lender can. Installment land contract. Seller retains real property's title until buyer takes final payment. Absolute deed. Transfers unrestricted title to real property. May actually be disguised mortgage if obligation is created contemporaneously with the transfer. Conditional sale and repurchase. Real property sold and then leased back to seller. If lease is for a long time with repurchase option, it may be a disguised mortgage. Transfer. Unless lender agrees to release, borrower remains liable after real property's transfer. Mortgagor's liability. If transferee assumes mortgage, then borrower is secondarily liable. If borrower makes payment, she can seek reimbursement from transferee. Borrower may get liability relief if lender impairs borrower's recourse right against transferee by modifying loan terms or releasing transferee of liability, or if lender releases or impairs real property subject to mortgage. Due on sale clause. Lender can demand immediate payment of full amount due. Due on encumbrance clause. Lender can accelerate mortgage on second mortgage. Transferee's liability. If transferee assumes mortgage, transferee is personally liable for mortgage obligation. If transferee takes real property subject to mortgage, then transferee is not personally liable on default, but real property may be sold at foreclosure sale. Pre-foreclosure rights and duties. Lien theory state. Mortgagee cannot take possession before foreclosure. Title theory state. Mortgagee theoretically is entitled to possession at any time, but typically cannot take possession until default by mortgage terms. Mortgagor has duty not to commit waste. Equity of redemption. After default but before foreclosure sale, mortgagor may regain his title by paying loan obligation currently owed plus interest. Can be unpaid loans full amount if acceleration clause exists. Foreclosure. Mortgagee takes real property when mortgagor defaults, no payment. We have methods, priority, effect on parties, proceeds distribution, and deficiency. Methods. Judicially supervised sale, private sale, or strict foreclosure. Priority. If two or more mortgages, foreclosure terminates junior interest and has no effect on senior. First in time, first in right. Purchase money mortgage exception. Mortgage given at time of real property's purchase generally has priority over mortgages and liens created by or that arose against purchaser mortgagor prior to purchaser mortgagor's property acquisition. Recording Act exception. Mortgage is subject to General Recording Act, so recorded interest may take priority over unrecorded one. Other exceptions. Subordination agreements, mortgage modifications and replacements, future advances, and after acquired property. Effect on parties. Mortgagor. Their interest is eliminated. Real property's purchaser takes property free of junior interest subject to senior. Senior interests are unaffected. Junior interests are destroyed. Proceeds distribution. Cost associated with sale, mortgage obligation being foreclosed, debtor mortgagor, mortgage obligation owed to junior interest holders in order of their interest priority. Deficiency. In most states, mortgagee is permitted to bring deficiency action against mortgagor and/or any party who has assumed the mortgage. Some states, no deficiency action when mortgagee forecloses via privately supervised foreclosure sale or when mortgage is purchased money mortgage. Some states limit total amount that may be recovered to property's fair market value. All right, let's take another break, a big break. You can pause the video here and come back when you like. All right, we're back. Let's talk about land use disputes. They involve easements, covenants running with the land, fixtures, government regulation of land, zoning, and other property rights, air, water, and support. Easement is a right held by one person to make specific limited use of another's land. We've got types, transfer, scope, termination, duty to maintain, and profits and licenses. Types: express, implied, prescription, estoppel, and negative. Express: affirmatively created by parties in writing that satisfies requirements for deed, by grant or by reservation. Implied: necessity: dominant or servient estates must have been under common ownership. Necessity must arise when property is severed and estates created. Property is virtually useless without benefit of easement across adjacent property. Implication: dominant or servient estates must have been under common ownership. Quasi-easement existed at severance. May also be implied from subdivision, map, or plat. I can't read that. Something use was continuous, apparent, or known. Plaintiff's use was continuous, apparent, or known. Easement reasonably necessary to dominant estate's use or enjoyment. Prescription: continuous, actual, open, and hostile for statutory period, 10, 15, or 20 years. Estoppel: good faith, reasonable, detrimental reliance on servient estate's permission, issued to prevent unjust enrichment. Negative: this prevents an owner from using land in specific ways, must be expressly created by grantor signed writing, and usually is only recognized for light, air, support, or stream water from artificial flow. All right, moving on to transfer. Easement appurtenant: benefit or burden transferred automatically with estate's transfer. Easement engross: benefits person, not estate. Burden is transferred automatically with servient estate transfer. Benefit is transferable if commercial or if parties intended it. Scope: court looks to use's reasonableness, original party's intent, and resolves ambiguities in grantee's favor. Termination: we've got release, merger, severance, abandonment, destruction, etc., and unrecorded. Release, by writing satisfying deed creation requirements. Merger. Easement merges into title when dominant or servient estate owner acquires fee title to other estate. Severance. Severed by attempt to convey a pertinent easement. Severed by attempt to convey a pertinent easement, separate from the land it benefits. Abandonment. Owner affirmatively acts to show clear intent to abandon right. Statements of intent without conduct and mere non-use are insufficient to extinguish. Destruction or condemnation, prescription, estoppel, necessity's end. Unrecorded express easement is not enforceable against bona fide purchaser for value of servient estate. Duty to maintain. Easement owner has right and duty to maintain the easement, may seek contribution from easement's co-owners for reasonable repairs and maintenance costs in proportion to their use. Profits. Entitles holder to enter servient land and take from it soil or some soil substance, such as mineral, timber, and oil. Created and analyzed similarly to easements, except profits cannot be created by necessity. Licenses. Privilege to enter one's land. Freely revocable unless coupled with interest or estoppel. May result in easement by estoppel. Need not satisfy the statute of frauds. Individual oral easements may create a license. Break. All right, covenants running with the land. We've got real covenants, equitable servitudes, implied reciprocal servitudes, real covenants and equitable servitudes enforcement defenses, transfer and termination, and finally, common ownership communities. Real covenants. We've got writing, intent, touch and concern, notice, and privity. Writing. Must comply with statute of frauds to be enforced as real covenant. Intent. Rights or duties run with the land, though through explicit language or implied from circumstances totality. Touch or concern. Benefit or burden must affect promisee or promisor as land's owners. Negative covenants. Run with the land if they restrict owners' use or enjoyment of land. Affirmative covenants. Run with the land if they require owner to do something related to land's use and enjoyment. Notice. Burden only. Must be constructive or actual. Privity. Horizontal privity. Burden only. Must be constructive or actual. Vertical privity. Covenant based on mutual or successive interest in land burdened or benefited by covenant. Modern trend is no privity requirement. Affirmative covenants run to successors of estate of same duration as original party's estate. Negative covenants are analyzed similarly to easements. All right, moving on. Equitable servitudes. Must be in writing, except for implied reciprocal servitudes. Requires intent for restriction to be enforceable by and against successors. Requires intent for restriction to be enforceable by and against successors. Must touch or concern, no privity required. If servitude is to be enforced against purchaser, notice, actual, record, or inquiry. Implied reciprocal servitudes. Intent to create servitude on all plots, a common scheme. No writing required. Negative servitude is a promise to refrain from doing something. Notice is actual record or inquiry. Or notice, actual record or inquiry by party against whom enforcement is sought. Real covenants and equitable servitudes enforcement defenses. Changed circumstances, latches, unclean hands, acquiescence, and estoppel. Transfer and termination. These real property rights and obligations are transferred along with real property itself. Notice is generally required to enforce them against a bona fide purchaser. They are terminated on release, merger, abandonment, estoppel, or condemnation. Common interest ownership communities. Individually owned units are burdened by covenant to pay association that provides services and enforces other covenants. We'll talk types, governance, and powers of community. Types. Property Owners Association. Condos. Owners own the unit and share of common interest areas. And then finally, co-ops. Governance. Governed by association which is overseen by a board of directors. Rules are laid out by declaration and other government docs. Powers of community. They can levy assessments for general upkeep, repairs, and improvements. They can manage, acquire, and improve common property. They can adopt rules governing property use, must not unreasonably interfere with the owner's rights. They can enforce governing docs and rules, and the community has corresponding duties. Break. All right, fixtures. The definition of a fixture is a chattel attached to real property such that it is treated as part of real property when determining its ownership. Trade fixture. Chattel used in trade or business attached to real property, like a restaurant oven. Structures built on real property and items incorporated into structure become part of realty but can be removed if seller reserves right to remove fixture and leased property can be restored to former condition without damage in reasonable time. Break. Government regulation of land, zoning. Local government's authority to regulate land use is usually enabling act granted. States have mostly delegated to local. Federal regulations are generally authorized by Article 4, Section 3, power over federal lands. Void regulations. Authority lack. Irrational or arbitrary. Must be rationally related to legitimate government purpose. Types. Based on use. Residential, commercial, industrial. Based on development, setbacks, density regulation. Based on special concerns, environmental protection, or historical preservation. Challenges. Based on takings clause, 14th Amendment substantive due process and equal protection, First Amendment freedom of speech, Fair Federal Housing Act, Federal Religious Land Use, Institutionalized Persons Act, and state constitution and statutes. Non-existing conforming property may be grandfathered in, possibly subject to amortization period. Nonconformity cannot be expanded. Can increase frequency or upgrade uses means if does not constitute substantial change. It can be transferred. Post-ordinance nonconforming property. Owner may request special exception permit or admin variance. Party seeking variance must show unique, unnecessary hardship, hardship not self-induced, and variance would not result in substantial harm. May be use or area variances, and they may be subject to conditions. Other zoning types: contract, permits in exchange for promises. Floating, rules regarding use not linked to particular area. Cluster, consider zoning requirements as whole, not lot by lot. Planned unit development, not focused on plots, but on entirety. Comprehensive plan, generally required, and development must adhere to the plan. Spot zoning is arbitrary discrimination against or in favor of rezoned property's owner. Relationship to covenants. Compliance with zoning restriction does not protect owner from suit for covenant breach. Compliance with covenant does not protect owner from zoning violation action. Break. All right, other property rights. We've got theories, support rights, air rights, and extra. Theories, riparian rights. Water belongs to those who own land bordering the watercourse. Owners may make any reasonable use of water. Water rights cannot be transferred separate and apart from adjoining land. Prior appropriation. Water rights are determined by priority of beneficial use. Subsequent users must not infringe on prior users' rights. Water rights may be transferred separately from adjoining land. Support rights. Right to have land supported in its natural state. Lateral support. 1. Undeveloped, no improvements. Landowner who excavates on his land is strictly liable for damage to undeveloped adjoining land. 2. Improvements. Landowner who excavates on his land is strictly liable only if the adjoining land would have collapsed in its undeveloped state. 3. Improvements contribute to collapse. Landowner who excavates on his land is only liable if he is negligent. Subjacent support. Mineral rights owner is strictly liable for any failure to support land and any buildings on land at the time rights were conveyed. Air rights. Landowner has limited right to reasonable use and enjoyment of airspace above his land, as long as it does not interfere with another's reasonable use and enjoyment of land. Extra. While landowners possess many property rights, there's no rights to sunlight, fresh air, or view. And we are done. Congratulations, you got through real property. We will see you on the next video.